Welcome back to another edition of Between Two Fars. I'm Warneke Miller, joined once again by Judge Reid Prouty, who's Vice Chairman of the Armed Services Board of Contract Appeals. We've been talking a little bit about routine motions and scheduling orders, but today we're rolling up our sleeves and we are jumping into discovery disputes, because we all know how much judges love you love discovery disputes, right?
Nothing better.
Talk to us a little bit about what you have to deal with a discovery dispute.
You bet. And of course, Warneke is joking because judges notoriously hate discovery disputes. When I was a litigator of justice, I knew that, sort of. I knew, they don't like discovery disputes. What I didn't realize is really how much they don't like discovery disputes. I want you to imagine it is as bad as you can possibly think, and then multiply by 10. And that's how we feel about discovery disputes. And there's a lot of reasons for that. The main one is that you have this sort of feeling of children, please behave. It is not advancing the case at all as far as the judge is concerned. The judge has to sort of put aside the substantive thing that they're working on and dive into the discovery dispute. And this case that has been on autopilot for hopefully months, maybe even a year or so since the last time the judge touched it, suddenly they have to get smart on the case again and remind me, oh yeah, what's going on in this case when they've got 30 or 40 other appeals going on. So as important as the case might be to you, it is very, very low on the judge's priority list, and pretty much the memory they've got about that case has already left their brain, so they've got to get back on point about it. And then they've got to make a decision. And oftentimes discovery disputes require us to sit down and read through a whole lot of documents and just thinking, why am I spending my time doing this when I could be doing something substantive to advance the ball? Now, I want to say up front, there are times when there's going to be discovery disputes and it's not your fault. It goes both with the contractor and the government. There can be times that, hey, you've made a legitimate discovery request and they're just not responding. Okay, well, that's a discovery dispute that if they're not going to respond, that's reasonable. There are going to be times when somebody's made a discovery request that is incredibly overbroad and impossible to comply with. And no matter what you do, they can't be satisfied and they're going to take it to the judge. Okay, well, that's not your fault. But the vast majority of discovery disputes are things that sort of fall in between. And a lot of it can be done with, what if you get a request for discovery that is just overly broad and won't get them the other side what they think it's going to get them, though it also just costs a fortune as far as the ability of the agency to respond to, or the contractor as well, for the other side. The key is to sort of get on the horn with your opposing counsel and say, what is it you're really trying to find out here? What is you looking for? And what can I help you? Be cooperative. When I was with the government, the view we were told to have was, we don't mind if they have all the facts, because that will get the right result at the end of the day. And for the NASA folks, that really should be your approach as well. Subject, of course, to attorney-client privilege, which will be a subject of another Between Two Fars. But to the degree that you can comply with the discovery request and give them what they want, that's helpful. Now, having said that, oftentimes, especially, it tends to happen more on the government sometimes, but also on the other side, the contractor side, people ask for things and say, well, you don't really need that. That's not really relevant, and that's not material, so I'm not going to give that to you.
We love when opposing counsel tells us that.
Right, because they know so much better.
Yes, they know our case. They know what we're after. And, I want you to imagine how a judge is going to look at that. Oh, well, you've decided it's not material. You've decided it's not relevant. Well, what are the rules in discovery? And the rules are very, very broad. Now, if you look at when I gave the introductory talk I gave Between Two Fars ago, I talked about how we basically have pretty vague rules for the Board of Contract Appeals, ASBCA right now, but in large part we harken back to the federal rules of civil procedure. And those federal rules basically say that something is discoverable if it could lead to more relevant information. So it's a very, very broad net.
And sometimes we forget that when we're responding to discovery. But the judges sure haven't forgotten it, and your opposing counsel, and they're asking for it, sure haven't forgotten it. So you got to keep in the back of your mind, is this the kind of thing that might lead to admissible evidence? And even if it itself is not admissible evidence, if it might lead to it, then you got to turn it over. And that's just the deal. And if you say, well, Your Honor, this would not be admissible, that's not going to be a very persuasive defense when there's a motion to compel out there. Now, when you are the person that's talking about bringing a fight in discovery, you're the one that's going to be making the motion to compel, we're going to want to see an email trail. The email trail is going to say, hey, I'm looking for this, you still haven't responded, when is it going to come in? Because usually the first hint that something is going wrong is when you've served the discovery and the deadline is passed and you haven't got anything for the opposing side. That's when the first email should go out and say, hey, what's going on? Do you need more time? Whatever the case might be. Be cooperative. And then as time goes on and you don't get what you need, make it really clear so we can have a trail to follow to show that the person that's bringing the motion is the one that's being the reasonable party here. Oftentimes it's a flux in both houses. Both parties are being unreasonable. That doesn't make life any more easy for us, but it certainly doesn't get you what you want. And what you want is the discovery. You don't really want to win a motion to compel if you can avoid it. What you really want is a discovery before you get the motion to compel. And the way to do that is to send email. Now realize, by the way, that every email you send to the opposing counsel
is going to show up in front of the judge if the dispute doesn't get resolved. So be nice, people, please. Be respectful.
Be respectful. And if they're asking you for discovery and you're responding in a dismissive email, that is not going to make you look very good to the judge either. Okay?
Yeah.
So
both ways.
Everything you write, one of my bosses used to talk about the Washington Post test. Imagine that anything you write for the government or for your client is going to wind up on the front page of the Washington Post. How would you feel about that? Because that's fine, then you're doing an okay job. If it's like the judge is going to read this, what is she or he going to think of me? They'll say you're trying to do your best job. That's what you want. You do that, and even though we're going to begrudge you for having a discovery dispute, we won't begrudge you as badly, and we'll be much more likely to give you what you want. I'll add, when you think about your discovery disputes, sometimes you might be over-aggressive in asking for discovery in the first instance. You might ask for things that you don't really think you need, you don't really think you want, and the other party might say, well, I'm not going to give this to you. And even if it is discoverable, ask yourself, technically discoverable, because again, very, very broad net. Ask yourself, is this something I want to go to the mat about? And is this really going to help my case? And if it's not, you might ask yourself in the first instance, is this something I should have asked for in discovery in the first instance? Or maybe you want to amend your discovery request to make it more compact and much easier to defend, and much more the kind of thing that, yeah, I can see why this is the kind of thing that this party really, really wants. For a lot of discovery disputes, the judge will have a status conference to discuss it. Not all the time. Sometimes we'll do it on papers. But be ready to sort of defend yourself and explain why this makes sense in the context of your case. The last thing I'll add is that when you're filing your motions on a discovery dispute, remember, your judge probably, and there may be differences in circumstances, but probably doesn't remember anything about your case, as critical as it is to you. So you might want to orient him or her to why, these borehole logs are important in the different citation case you've got. Why in the context of a dispute before the judge, and remind the judge what the dispute is about. Make it short, but remind her or him what it's about. Why this is important, and why it really gets the crux of the matter, and why it's worth inciting the judge's rage by filing your motion to compel. And a final thing is, if there's been a motion to compel and it has not been compelled, if it's been granted and then they're still not complying with it, and you want to ask for sanctions, which we hope never to get there, think very clearly about what exactly it is you want. don't just say sanctions. What do you want? What is reasonable to request? What are you likely to get? And with that in mind, please, please, please cooperate in discovery and don't get there in the first place, if you can help it.
What sort of sanction requests would be appropriate? Asking that certain of their evidence be excluded from being able to be admissible, or a finding of a certain fact against them? Are those the type of specific sanctions you would want the party to move for?
That's a good question. And those are big guns, right?
Yeah.
And basically, if you're going to exclude evidence or exclude defenses, which is very possible, that might be the kind of thing that could be outcome dispositive. And if it is outcome dispositive, you're going to have a 3-judge decision, which is, as you'll find out in a later episode, a big deal and a bigger pain. Sometimes people are going to ask for sanctions, for monetary sanctions. Usually the government doesn't ask for that because it's not set up that attorney hours are charged a certain amount and things like that. So, at the most, you might ask that a certain defense not be able to, or certain kinds of evidence not be allowed to be put on. Hopefully you never get there. But it can happen. Which leads me to one more thing, which is spoliation of evidence.
Oh, yeah.
This especially became a big deal during the e-discovery. As many of you know, if the government or the contractor has evidence in their possession at some point, and then allows it to be destroyed, either on purpose or just by a function of timing going on, sometimes bad things can happen to the party that doesn't save their evidence. For the government, a lot of times you'll see this in emails where somebody retires, and as a routine matter, their email gets wiped after 60 days or whatever time that the agency has for that. And this could be a very big deal if it's a contracting officer. It could be a very big deal if the contractor has their project manager and she or he retires, and the same thing happens, and you just can't get back to the email because the email is very important, very discoverable, and sorry, we can't give it to you because we destroyed it. And that's called spoliation of evidence. And there's a lot of law on that. But I guess the big thing is, it's really good not to have to get to that law. So as soon as you hear about litigation, or you think there's a case that's going to be in litigation, please, please, please do everything you can to have your IT people save people's IT accounts, even people who are about to retire. They know how to do this. Through long and hard experience, every government agency has ultimately found out a way of doing the litigation hold, the litigation freeze letters. Do them, because if the stuff is destroyed in the normal course of business, and it was really clear that this person was the contracting officer's technical representative in a very dispute-laden contract, we're going to expect you all to save that. Save yourself the trouble of getting in trouble for that by saving it, if I can be repetitive.
No, and yes, we've discussed the importance of litigation hold letters in other Between Two Fars episodes, and I did want to ask one question about the packaging for some of these back and forth discovery disputes where you've got the long email chain showing that you've asked and you've amended what you're requesting and you're waiting. And is a visual helpful? Like, would you like a one-page timeline that's backed up by these emails? Is something like that sort of tells the story to the judge in a visually pleasing format helpful, or does that just seem like overkill?
It depends.
Okay.
Like everything else. It depends on how complicated the story is. It depends on the judge. Some judges are probably going to be like that more than others would like it.
Okay.
But certainly a bullet points of what happened are not unhelpful.
Okay.
Having a sort of procedural history is not unhelpful. I will say myself, when I write, I like to have headers for things. So frankly, one good way of sort of presenting a discovery dispute would be, a header on this date, the discovery is served. You basically have a paragraph saying what was in the discovery that was served. It was not responded to, the next header or something like that. Whatever works in your style of writing. But certainly that didn't hurt. It wouldn't hurt to have somewhere a pretty clear timeline so the judge could sort of see what happened.
Excellent. Thank you very much for walking us through what we hope never happens, but inevitably there are discovery disputes. We've still got more to talk about with Judge Prouty. Just the ASBCA is a multi-layered organization, and as you all know, once you get pulled up for a claim that it goes into active litigation, it does tend to become an all-consuming thing for the life of the attorney and the witnesses and the contracting officer. So while we've got Judge Prouty here, we're just going to continue to poke and prod a little bit more and get some more information that might help us the next time we find ourselves in front of the Armed Services Board of Contract Appeals. Join us again next time, Between Two FARs.